Section 8, Information and Undertaking regarding foreign applications. Section 8 is applicable only in instances where an applicant who makes an application in India also files an application in a country outside India, that is a foreign application, in respect of something which is similar to the invention or substantially the same. It has to be the same invention or slight modification. Largely the invention is the same. So, if the invention is same and if an application has been filed in India, if there are any corresponding foreign applications, there is a duty cast on the applicant to furnish some information with regard to foreign application. So, section 8 will apply only in cases where there are corresponding foreign applications filed. It will not apply in a case where a person prefers Indian application alone. So, it will not apply in those cases. Now, why is this provision there? Now, one of the reasons for this provision is that not all patent offices have some duty to cooperate with each other, or do they have an arrangement where they can share information filed by different applicants before them. For instance, the Indian Patent Office will not have any arrangement with the Japanese Patent Office or the European Patent Office to understand who is filing what invention and to disclose that. Obviously, many of the filings, once they get published, get into the public domain, but there is no duty of cooperation between the patent offices. So, in such cases, the duty to share information about a pending foreign application is casted on the applicant. Now, why should the applicant disclose this? Why can't the applicant just file an application in India, prosecute it, and not disclose this to the patent office as to what is happening to his other application, which he would have filed in other jurisdictions? One reason behind this provision is that the patent office needs to be kept informed as to what is happening in other jurisdictions with regard to the same application. It does not mean that the patent office will follow a decision taken by another patent office or in another country. The decision whether to grant or reject the application will be influenced by the decision of another patent office. It merely means that there is a duty casted on the applicant to share information on what has happened to his other applications, which are substantially the same. Section 8, subsection 1, where an applicant for a patent under this act is prosecuting either alone or jointly with any other person an application for a patent in any country outside India in respect of the same or substantially the same invention. So, the invention can be same or it could also be substantially the same, because you will know that patents are never granted in the manner in which they are applied for. In very rare cases, they are granted in the way in which they are applied for. Prosecution or the scrutiny by the patent office will require the applicant to make some changes, to give up certain things, to narrow down the scope of invention, and all these things could happen based on the objections raised by the patent office. And patent offices, because they do not cooperate and work with each other, the objections that a patent office would raise on a same invention can substantially vary from one patent office to another. So, the end result of an invention that is granted based on the same patent application would look different in different jurisdictions. For instance, in India, a method of treatment cannot be the subject matter of a patent. So, if there is a claim on a method of treatment, most likely that will be struck off by the Indian Patent Office, whereas a claim for a method of treatment may get granted by the United States, and it could be one of the claims that is covered for the invention. So, even though the method of treatment is just one of the many claims in that invention, it will still be regarded as substantially the same invention, though the corresponding application in India may not have the method of treatment claim. So, that is why the wording in section 8 refers to not only the same invention, but it also refers to substantially the same, meaning which even if small changes have occurred in the course of prosecution or even before filing the application, still it will be regarded as the same invention. Section 8(1) continues, or where to his knowledge such an application is being prosecuted by some person through whom he claims, or by some person deriving title from him, he shall file along with his application or subsequently within the prescribed time as the controller may allow. So it is not necessary that the applicant should be prosecuting the application, it could be somebody who claims through him. Still there is a duty cast on the applicant to give the following information. Now this could be filed, the information that is required could be filed along with the application, that is an option given to the applicant, or subsequently within the period prescribed. And we had already mentioned this, wherever you find this term period prescribed, time prescribed, form prescribed, then the details are most likely to be in the rules. A statement setting out detailed particulars of such application, a statement showing the application, details of the application, application number, the patent office in which it is preferred, date of filing, all the details, and an undertaking that up to the date of grant of the patent in India, he would keep the controller informed in writing from time to time of detailed particulars as required under clause A in respect of every other application relating to the same or substantially the same invention, if any, filed in any country outside India subsequent to the filing of the statement referred to in the aforesaid clause within the prescribed time. Now the first one is a statement that the applicant discloses all the pending or other applications which are substantially the same, that the application number, the patent office before which it is filed, the details, the date on which it is filed. And the second thing is that the applicant gives an undertaking. The undertaking is that he will hold or he will keep the controller informed in writing from time to time the status of every other application he has filed outside India. So there are instances where some pharmaceutical companies file 30 odd or 50 odd applications around the world using the PCT mechanism or the convention mechanism. In all those cases, if there is an application pending in India, the applicant is duty bound to disclose the status of all the other 30 odd or 50 odd applications that are pending elsewhere. And this undertaking will hold good, or the applicant will have to keep the undertaking up until the grant of the patent in India. So as I said, this gives the patent office the benefit of what is happening in other jurisdictions. So let us take a hypothetical instance where an application is filed in 10 jurisdictions including India, and during the course of the prosecution 7 major jurisdictions have rejected that application. And when the application comes for examination in India, this will give the patent office an extra information that if 7 major patent offices have rejected this application, then the patent office will probably look at that application more seriously, or it will take much more studied view of that application, because now the patent office knows the status of what happened to the same application in 7 other major jurisdictions. So this is a way in which the patent office can know what is happening to similar applications in other jurisdictions, but this is not through a cooperation between the patent offices, rather the duty is casted on the applicant to furnish this information. 8.2 says at any time after the application for the patent is filed in India until the grant of the patent or refusal to grant the patent made thereon, the controller may also require the applicant to furnish details as may be prescribed relating to the processing of application in a country outside India, and in that event the applicant shall furnish to the controller information available with him within such period as may be prescribed. Now 8.2 gives the controller the power to require the applicant to furnish details. The first one, 8.1, is where the applicant has to furnish certain details. 8.2 gives the controller the power to require the applicant to furnish details. So the first one we will understand 8.1 as voluntary act which the applicant has to do within the stipulated time. 8.2 gives the right for the controller to ask for details. The corresponding rule is Rule 12 and the corresponding form is Form 3. Form 3 is the form in which a statement and undertaking under Section 8 is made. The corresponding rule is Rule 12. Now, Rule 12(1) tells us that it shall be made in Form 3, and the period within which the applicant shall file the statement shall be 6 months from the date of filing. The Act said shall be filed within the time prescribed. There is an option to file it immediately along with the application, or if that is not done within 6 months time, it has to be done. And the explanation says how the 6 month has to be computed. In case of an international application, it will be reckoned from the actual date on which the corresponding application is filed in India. Now, Rule 12(2) states that the time within which the applicant for a patent shall keep the controller informed in respect of other applications filed in any other country shall be 6 months from the date of such filing. So, the time within which the applicant shall keep the patent office informed. So, if there is an application filed in a jurisdiction, then within 6 months the information has to be communicated to the controller. 12(3) says that when so required by the controller under subsection 2 of section 8. So, we mentioned that 8(1) is casts a duty on the applicant to file it voluntarily, he has to do it on his own. 8(2) gives the power to the controller to ask for information. So, when so required by the controller under 8(2), the applicant shall furnish information relating to objections, if any, in respect of novelty and patentability of an invention and any other particular as the controller may require, which may include claims of application allowed within 6 months from the date of such communication to the controller. 8(1) casts a duty to share the application details and undertaking that he will give further information. Once that is done, the controller can look at the Form 3, and if the controller finds that there are multiple applications pending in other jurisdictions, obviously the controller will have the right to search and find out what is the status in those jurisdictions. Now, assume that there has been an objection on patentability, a novelty objection or an inventive step objection in a foreign patent office, and the controller comes to know that this has happened. The controller can ask the applicant to furnish information relating to those objections, because in some cases these documents may not be in the public domain. So, the 8(2) allows the controller to ask for those documents. So, again, as we said, the legislative objective in having this provision is to allow the patent office in India to take informed decision. So, if there is something that has gone wrong on the same application in another jurisdiction, then the controller can get the benefit of that decision. Again, the time period prescribed in 12(3) is 6 months from the date of communication by the controller. So, when the controller sends a request asking details to be furnished, that has to be done within 6 months. Now, let us come to Form 3. You will find that these are the details that the applicant has to furnish: name of the country, date of application, application number, status of application, date of publication, date of grant in all the jurisdictions where it is pending. So, the clause 2 deals with the information on the application, and clause 3 here talks about the declaration. Now, the declaration is, I.V. undertake that up to the date of grant of the patent of the controller, I.V. would keep him informed in writing the details regarding corresponding applications for patent filed outside India within 6 months from the date of filing of such application. So, this is the undertaking. So, we saw in the language of section 8, there is a statement and an undertaking. The statement is in clause 2 of Form 3 and the undertaking is in clause 3.